and I am your financial hostess today. Hello, everybody. I'm officially live. I am Maria Magwaza. I am your financial hostess today. I have to start off by apologizing profusely to the people that have been waiting for a while. We have figured out that there is a little bit of a technical problem with regards to the link. Some people did join the session much earlier than 2 o'clock, and we were scheduled to start at 2. So we really apologize for that mishap. We are investigating what's going on so that we can correct that. I am a little bit disappointed that we may have lost a couple of people, but for those of you that are still on, please stay on. I realize that other people may need to jump off for 2 o'clock to get into other meetings, but we truly would appreciate if you could stay on. If you had colleagues who were talking about joining the session, who were excited about the session, please just have them come back on. We have to try and figure out what happened with the link. We are extremely apologetic about it. We have no clue what happened. We were trying to figure out, do we have different time zones in the country? Is it calculating on a different one for each person? Because some people do have the 2 o'clock and some people unfortunately got for 1 o'clock. So I am incredibly sorry for the mishap and the delay and any kind of inconvenience that waiting for us has caused you today. But without further ado, I do want us to kick off the session while we still have a couple of minutes before the top of the hour. And I would like for you to please kindly use these couple of minutes just to reach back to the people that were on call with us before, the colleagues that were very interested in this topic but had to jump off because they had been waiting for so long. Please give them a nudge, send them an SMS, call them, tell them we are here. The session has started. They can come back onto the session. We're ready. As per usual, if you've been into one of these sessions before, we use Menti polling to actually communicate with each other. The polling system allows for everybody to remain anonymous, so that's why we actually quite favor it. We don't have a problem with using the Q&A, nor do we have a problem with using the chat function. Whichever way you would like to communicate, we're very happy to receive that communication. So in order for us to keep interactive, please, may I ask you guys to kindly click on the link. I'm going to put the link in the Q&A. I'm going to put the link in the chat. I'm going to put it on all places so that whatever may happen or whatever technical glitch is thinking of happening doesn't actually distract us. There we go. Liana's also kind enough to paste it for me in the Q&A too, in order for everybody to please access this. Hello, Ruth. So thank you so much for joining us, guys. We are also looking forward to the session. It's incredible that September is here. It's Wills Month. So that's why we picked this particular topic. It is a minute before the hour. We're going to kick our session off at exactly 2 o'clock. I just wanted in the meantime for you guys to let us know, how are you feeling? How are you feeling today? The weather did take a turn for us in Joburg, so we're not sure how we're feeling maybe. Today it's like we're back to winter again. Lynn is unable to hear anything. I'm not too sure if everybody else can hear me or if you guys are struggling. If you are struggling, please let me know. Lynn, if it is just yourself, I think maybe we could leave the room and join the link again. That might help. It might help. Hello, Joseph. Very cold day in Joburg and Gauteng, actually, you're right. So I think all of us want to stay warm. But thank you so much. Okay, we're at the top of the hour. I'm not going to waste much time. Today's session is really jam-packed with information. And I've got with me two very knowledgeable speakers that will be sharing the floor with me. I am Maria Magwaza. If you've been here before, you know exactly who I am. I'll be your financial hostess for today. And I've got with me Liana Henning, who is our head of wellness. And we've got together with her Yolanda Botha, who is our wills specialist. So hello, ladies. Welcome.
Hello. Thank you so much.
Good afternoon. Good afternoon to all of our attendees. Thank you for joining us. And Maria, looking forward to the session with you being our host.
Me too. Me as well. Thank you for those that have waited since 1 o'clock. It will be worth your while. I'm very sorry for making you wait. It is outside of our control. Unfortunately, we don't know what technology is doing, but we are going to investigate. So thank you so much for your patience. Today, we're going to get into a very interesting topic, and I think we're going to be starting off with, is it part of financial wellness? Why is it important? We're going to be looking at the importance of having a will in place, some of the jargon around the paperwork of a will. We're going to be looking at terminology in terms of, what appears on the actual will, but things to consider. Costs. What happens if I pass away without one? How do I plan to get one? So we're going to have this session really, really be interesting. I am going to ask you guys to please put your questions in the chat function. So you can put it in the Q&A as soon as it hits your mind, because you will forget it. Information is so interesting here. You will definitely forget it. If you see that we're not really quite getting to your question, I'll keep up with the chat. It might be because it's already part of our content. But please just ask a question, even if you know how we do things here. Even if you say you're asking for a friend, that's okay. We want to keep it private. So we're going to kick off with our two ladies, and I'm going to just, ask you guys here and there, questions around the wills and things like that. But I did want you guys to just give a little bit of background for those that don't know who you are, and then we'll be able to kick off. Liana, can I start with you? Do you mind introducing yourself?
Thank you so much, Maria. Yes, my name is Liana Henning. I head up client services and training. I've been in the financial wellness space for the last 18 years, and prior to that, I worked for one of the banks for 10 years. So in total, 28 years in the financial space, passionate about financial literacy, financial coaching, and really sharing knowledge and insight. So thank you so much for that opportunity, Maria.
Good afternoon, everybody. I'm Yolanda Bueta. I am with Capital Legacy, and I've been in the wills and estates industry now for 18 years. My passion is educating people in and around wills and what happens if you do pass away eventually. Thank you so much for the session.
Thank you for adding eventually at the back of that, Yolanda. People were thinking, wait, what? What's going to happen? So thank you so much, ladies. I'm going to try and keep my camera off as much as possible so that we can see our slide deck nicely, but we can see our experts for today so that they can take us through this very, very important topic. So I want to kick off. I want us to get on the same page. I want us to actually start off with Liana. So Liana, when it comes to our financial lives, what are some of the things that perhaps we have in common? Because we don't know each other from a bar of soap on this call. We mixed from all different walks of life, but what can you say from a financial perspective we all have in common?
Maria, I think there's a couple of things that we have in common. And the very first thing is that we are working to earn an income, and sadly, we are all going to die. But some of the other common denominators would be that, we are consumers. So we feel the cost of living and the increase of cost of living. We feel the interest rate increases when we have credit facilities. And of course, we know that life happens. Now, very often in this journey called life, there might be positive and some negative events. Some of the positive events could be starting a new relationship, thinking about commitment, or maybe there's a little one on the way. You might be growing your family. Some of the negative life events that could have an impact on us, of course, is losing a loved one, change in your circumstances, loss of income. So there's a couple of things that we have in common, but I think one of the most important things is the reality that so many people do not set time aside to manage their finances effectively. We know that we tend to live in the moment. In fact, it's said that around 96% of people are unable to retire comfortably. It's also said that around 70 to 75% of people do not have a will in place. And the reality is very often people spend more time planning a birthday party, a weekend away, or a holiday compared to the time that they set aside to manage and plan their finances effectively.
You mentioned something very important there, Liana, about people not making time to do these things. I just want to rope Yolanda in as a will specialist. And Liana, you can also jump in here. why do you think people put off, drafting a will? Why is it? Do you have reasons that they've given?
Maria, there's a lot of reasons, but I'm going to give you the top 3. So firstly, our clients would feel you need to be very rich before you can draft a will, which is not the case. Okay. If you have a belly button and you earn an income, you need a will, because where's your income going to go to? All we work for, we work hard, and we would like our loved ones to receive our inheritance one day. So that's the first thing. Secondly, my clients do feel if they draft a will, they are going to pass away. And then also, thirdly, they feel it's going to cause drama. It's going to cause them to get killed. So they don't want the family to know that they're drafting a will, because then there's drama even before the death. Those are the 3 reasons, top 3, I would say. Thank you, Maria.
Jeez. So that's very interesting. I'm going to drop our Menti link again in the Q&A and in the chat function. And I do want you guys to just weigh in here before Liana gives me some of her reasons also that she's heard along the way why people don't want to do this. So I'm asking you now, we're asking the audience, why haven't you done it? Why do you think you wouldn't want to do it? What would be your main reason? Why do you think we avoid it? Why do you avoid it? And I think also for me, it's positioning. So that's why I was asking the ladies, what were the reasons that were given? So while we wait for the responses, Liana, did you ever hear anything different from what Yolanda was saying?
I think that's her top 3 reasons are very important, but I also know very often people lack the skill and the ability or financial literacy, and they might think that it's complicated to draft a will, or they might not know where to turn to draft a will. By glancing at our Q&A, there's already questions that's coming up. People asking, but do I do this through the bank? Do I do it privately? Where do I do this? And throughout our session, we'll definitely be touching on those options. But I also want to say that people might think that they don't have enough assets, or that they are too young to actually draft a will. And we'll be touching on when should you be drafting a will. And by looking at some of the responses coming in, I'm not sure how to split it. I'm feeling overwhelmed. It's expensive. I don't have the knowledge. I did not see the point. So a lot of those responses coming in. But Maria, from a cultural perspective, can you share anything with us? Why is it that in some cultures people just avoid the subject completely?
I can speak only from mine, and I'm very glad you asked me that one, because culturally, I think, we don't have them, or maybe my parents' generation didn't want to have them, because it's almost like bad to be gaining from somebody's passing. People look at it as like gains, it's like the benefits. There's a specific Sotho saying, they say, which means your death, made me benefit. And I think benefit is the wrong word, and that's created the stigma attached to, creating a will. It's not that I'm benefiting. I'm actually finding a way to substitute income or make up for the income or survive actually without this person. So for them, it's almost like, oh, okay, you're going to benefit. Like Yola said now, it's like I'm going to immediately die after I draft a will. So culturally, I think for me, that's been the biggest thing that I've seen. So I've got the answers, and I can see you're right, Liana. Everybody's quite split. It's knowledge, it's time, it's expensive. I didn't know. I wanted to use a case study, and I wanted to, almost make it real. If somebody like Joe, who's married with 2 children, would come to you guys and say, please help me, but Joe has obviously got his kids, and he's updated his beneficiary nomination forms. He's got his wife and 2 children, but he didn't have a will in place. Is Joe safe? Is it fine? Because at least his beneficiary nomination forms are updated. What do we do with him at first? What do we do with Joe's case? Yolanda, can I ask you to speak to this case study?
Sure. Thank you, Maria. So firstly, any children under the age of 18 are not allowed to receive any inheritance unless there's a will and a testamentary trust. So your first answer should be, with regards to his will, no, he is not covered. very important to remember that your beneficiary nomination forms and your will, they are two separate things. Okay, so your will does not override your beneficiary nomination form and the other way around. It is very important to keep both of them updated and fresh at all times. Liana, if you would like to add?
Yeah, absolutely. And as we look at some of these points on the slide, no will, no way. And I know it's a mouthful. We say that when you pass away without a will, it's according to that Interstate Succession Act. And that simply means that the state will then decide how they are going to distribute your belongings. And that is really something that you don't want. If you are married, then obviously the estate, and let's just maybe clarify, estate, when we talk about estate, that refers to everything, your assets, your belongings, everything that you own. How would that be distributed? So to look at some of these points, if you are married, it would go to the spouse. If there's children, it would then go to the kids in equal shares. If there's one spouse and children, it will be divided. If you are single and you don't have any children, it would go to your parents if they are still alive. And then, of course, if only one parent is alive, 50% would go to the parent and the balance to your siblings. And from there, we've got to look at the reality that if there is no parents, it would go to your siblings in equal shares. But think about it. If there's no spouse, no children, no parents, no siblings or nieces or nephews, it would go to the nearest blood relatives. And you can see that this process in itself will take an extremely long time to try and wrap up the estate. And I always think about this, if there's no will in place and I didn't specify what should go to who, then family members that I've got absolutely no relationship with, or I haven't seen them in the last 30 years, is going to benefit from my estate. And that's not necessarily what you want. So it's very, very important to have that will in place, because if there isn't a will in place, we know that the court will appoint someone. We talk about the executor. We're going to explain all of those terms to you. And we know that the laws around it is very rigid. It can take very long. And we also know that if there is minor children, and we're definitely going to pause and talk about minor children in the Guardians Fund, we know that if there's kids under the age of 18, they might not receive that inheritance because of various reasons, which we are going to disclose. So I think the most important message that I want to bring across today is that if there's no will, there's no way. So please do reach out and draft that will, and we're going to give you some drafting options.
Like that. So Nolene, you asked that very same question that's similar to the case study we just did now. So I hope that answers your question. This is exactly what I mean. Write down that question. It does not matter if it's long, if it's short, if it's for a friend, or if it's for you. Please just write it down so that if we don't have it in the content, you get the opportunity to get it answered. Now, we did touch a little bit on the Guardians Fund, but I want to know, why is it not a good thing to have the money placed in a Guardians Fund? Because it's a fund, right? So it means that somebody's taking care of it. Yolanda, do you want to give us insight about the Government Guardians Fund?
Yes, please. I would love to. So firstly, the Guardians Fund is a government authority. It is run by the Master of the High Court. It's called the Guardians Fund, but this does not necessarily mean that the Guardians has full access to this fund. Most recently, we received a bit of communication that in this fund, there was 16 billion rands theft. Okay. And up until July, there was actually 18 million rand. Right. Theft. Because of this, they have also now frozen this account. So if you remember what I said previously, children under the age of 18 are not allowed to receive their inheritance. So now if you don't have a will, then this money will go into this fund. In order to make sure this does not happen, you need to create a will with a testamentary trust in it. Right. So that's very important. We don't want this to... I don't want my children's inheritance to go into this fund. Now this fund is frozen. And as we know, Maria and Liana, kids, they cost a lot of money, and we need funds daily to look after them. If it's not spring day, I don't know, still pay 5 or 10 rand to wear our spring clothes. So if it's not that, what some of the big 5 life companies are doing at the moment, they will call up the guardian, which might be your ex-husband. And I saw that there was a question, how do you protect your children from your ex-husband? He might be the guardian. So remember, we will get there later, but if you appoint a guardian, it's only if the other biological parents, are no longer there. So what you then do, you would rather create a testamentary trust, and you would appoint a co-trustee together with a trustee of a fiduciary company, for instance, to make sure that that ex-husband or the biological parent do not have full access to that fund. It must be approved by your executor or the trustees together with the co-trustee that you've actually nominated.
Awesome. So you touched on a couple of things. There's a testamentary trust, there's a guidance fund. So I wanted us to get into what is a will to start with, because some people did say, it's the know-how. I don't have the know-how. So let's talk through what is a will first, what is considered to be a legal will. And then the next thing is we're going to get into when you should draft one. And then we're going to break down some of the things that you've touched on there. Zanele, I hope that Yolanda has answered your question with regards to the minor children, but there are other questions also that are going to be answered, so hang in there. Liana, if you can take me through what a will is and the advantages of having one.
Yes, Maria, I think really let's take it down to the basics. And a will, of course, is a legal document that you need to draft. And in this document, you get to express your wishes. So when you are no longer around, I always say it's like someone steps into your shoes and they will then execute your final wishes. It also gives you an opportunity to explain and set out who needs to inherit what, so there's no drama. You can nominate the executor, of course, being the entity or the person that's going to then execute this will. And later on, we'll talk about who you can select as the executor, why you want to select certain institutions or individual. And of course, you can nominate the guardian, who's going to take care of your children when both biological parents are no longer around. So that's very important to understand. And I know Yolanda will be touching on, if the one parent is not fit to take care of the kids, how do I actually get past that? We also need to think about setting up a testamentary trust. That is, of course, for your minor children. The trust is set up when you pass, and that's usually done by the executor, and they will then appoint trustees who's going to act on your behalf and make sure that the assets is distributed accordingly and that the kids' needs are taken care of. Now, the advantages of having a will links back to what is a will. It gives you that opportunity to select your beneficiaries. The state or the master's office is not going to decide who inherits what. You have stipulated, and you can of course choose your own executor, where if you don't have a will, a state executor will be appointed, and of course you can nominate your guardian. Now I want to pause just on nominating your guardian, because remember, this is when both biological parents are no longer around. And I always share the story. I've got 2 daughters, 19 and 15, and I remember when they were much younger, it was such a challenge and so difficult for myself and my husband to actually decide who the guardian of the kids should be. And I've changed my guardians more than 3 times over the last 19 years, because relationships change and you need to see who your kids feel comfortable with and who would raise them in a similar manner that you would raise them. But it is important to have this discussion with the guardian and notify them that you are selecting them, because you don't want to place them in a situation where they actually can't take on the kids because of where they might find themselves in their particular life stage. And then, of course, very important, when you draft your will, you'll have the guidance of a will specialist or a consultant that can help you structure your will in the most effective way, because there are certain fees applicable. There's estate duty, there's tax, etc. So we need to really make sure that you get that professional guidance when you draft your will.
Very, very important. Now, Yolanda, if you can jump in with regards to who then drafts a will, because we spoke about, is it too expensive? I don't have enough. Am I the right person? So who should draft a will?
Thank you, Maria. So according to me, everybody should have a will, right? Everybody in this call should have a will. So firstly, as I said to you, if you have an ID number, you need a will. If you earn an income, you need a will. Why? Because eventually anybody with an ID number might even have a cell phone account or might have a car that they're paying off. All of those things needs to be winded up at the end of the day. So it's not just about distributing the assets. It's also about finalizing your estate when you do pass away. And if you don't have a will with an executor and trustees, things might not be going the way that you would like them to. Right. So firstly, anybody older than 16 can draft a will. But I know Liana always said if she refers to her 16-year-old, what she would leave in her will, it might be her cat and her phone and her iPhone. So they don't necessarily have to have a will. But especially if you look at a 16-year-old who maybe inherited, that 16-year-old will need a will, but they need to understand the nature, and they also need to understand, they would need to be able to stand in court and understand what the act that what they've just done. They need to understand that. Who should be drafting a will? Anybody with the above criteria. If you have minor children, as we said, we don't want your children's inheritance to go to the guardian's fund. Anybody with assets, even though it's owed by the bank still. This is very important because we feel this is not my asset because the bank owes. The bank, I still owe the bank lots of money for my car and my house, so it's not my asset. Unfortunately, if your ID number is on it, it is your asset, all right? And then very important, anybody who's in a common law relationship. So I'm actually going to ask the people on the call if they know how long do you have to be, or how long do you have to stay or live with a person before you are a common law spouse? I would love to see some of the responses. Maria, do you know how long do you have to stay with someone before it's common law?
I'm going to chance
give it a bash.
I'm going to chance it and say 6 months.
Okay, good guess though.
Let's see if other people will put it in there because, there we go.
Thank you, Joanna.
6 months.
6 months. 3 months. Thank you, Andre.
Yes, coming in.
The way your face lit up, Yola, I think Andre might be onto something because your face gave you away. Sinentlantla also says 6 months. Anita says a month. So we all have different,
Yeah. And that's the problem, Maria. So this is why we're doing sessions like this, because thank you, Donald. There we go. So common law hasn't been promulgated. It doesn't exist, guys. Ladies and gents, it doesn't exist. So yes, I've had an audience before where they said, if my toothbrush is if her toothbrush is in the bathroom, then we're common law. So that's also not correct. So thank you for everybody's answers, but unfortunately, it hasn't been promulgated. Maria and Leona, and this causes huge problems because I've seen in the industry people, they built a life together, they have kids together, and now one of them passes away, they don't have a will. So now they don't form part of that family tree, and it will go to the children. If they're under 18, their share will go to the guardian's fund, and that common law spouse or life partner gets nothing. So it's very important that if you're in a relationship like that, please make sure that both of you have a will and not just one of you. Thank you.
So thank you for that. Another question of how often you should draft this, and I think somebody asked this indirectly, Yola, but just to say, I am divorced and I want to keep my assets away from, said ex-partner, or my children are staying with this one or that one. So I think this question might answer some of their questions in that regard. How often do I need to update a will?
So just to answer that question, you only have 3 months to change your will after a divorce. If you do not do that and your name is still on the previous will or the other way around, that spouse will still inherit. So you only have 3 months. The only way that you can make sure that the ex-spouse can't touch it is by updating your will and having a will. All right. Okay. That's the most important thing. And yes, just remember, if you have any maintenance agreements or divorce agreements where there's monies that needs to be paid every month, that doesn't die with you. Okay. So it's very important that you make sure that there are enough funds. And I know Liana will touch on this. Make sure that there's enough funds when you pass away. Those things needs to be paid first before anybody gets anything. Over to you, Liana.
A quick one before Liana jumps in. So we did mention here a marriage, right? If you get remarried, if you get divorced, and Sinenhlanhla is asking an important question about what about having a lobola negotiation? Do I then update it because I'm not necessarily legally married? I've now been paid lobola for. Can I then go ahead and update my will in that regard? Is that marriage? And is the legal letter of lobola representative of something that can stand as proof to have been married?
Yes. So I would update my will and I will put the proof on the copy for the executor to make sure.
Okay, stunning. Liana, do you want to weigh in here with regards to when to change the will?
Yeah, I actually always say when there's a life-changing event, you need to update that. So whether that is entering into a new relationship, a divorce, a separation, the birth of a new child, you also need to think about who you nominated as your beneficiaries. If that beneficiary passes away, you need to think about who's next in line, and is that your intention for that person that's next in line to receive that? So whenever there's a life-changing event, and it's not just, thinking about a partner or spouse, you've got to think almost 2 or 3 levels down the line. So for me, that is quite important.
So here's the question. I wanted you to just walk us through what happens when somebody passes away. I think a lot of people, if you haven't gone through this, you're very, very lucky. I think it's just few and far between that people haven't really gone through the whole process of losing a loved one. We always focus on the head and the heart. So I wanted us to just go through admin-wise, logistically, what happens when somebody passes away, and how does this actually feature in terms of having a will or having prepared for a passing?
Definitely, Maria, and this is actually where our session gets a bit deeper now, and where we talk about the process. And really what happens is when you lose a loved one, a death certificate will be issued. So it means that the death needs to be reported at the master of the court within 14 days of death. And usually this is done on behalf of the loved ones, but really no action can be taken until the executor letter has been issued. Now, if there's no will, it means that no executor has been appointed. So that process will be delayed by months, could even be a year down the line. It also means that bank accounts need to be frozen, so the surviving family members, spouses, partners will not have access to that person's account. And if they've been relying on that person financially, it of course leaves a big gap in terms of financial support. There would be no liquidity, no cash available. So you need to notify credit providers. You need to start looking for documents. And this is the worst part, if you've lost someone and you're not sure what their financial standing was there a will? Where do I find it? Do I go to the place of employment? Who do I need to talk to? And I know we're going to talk about the importance of having an in case of emergency file as well. But then you also need to think about the funeral. Now you're mourning the loss of a loved one. You've got to deal with the undertakers and the funeral home. You've got to then, of course, also just pause and think about your personal emotions. And there's usually 5 stages that we go through. And this is in no particular order. And I also can't say to you what the time frame should be for every person, but it's pretty much the denial. You don't want to believe that this has happened. Some people then isolate themselves to deal with their emotions. Some people feel angry or they start bargaining around this. Many people fall into depression, and slowly but surely as time goes by, we might start accepting it. But the reality is that there's a 6th stage, and that unfortunately is greed. And many families might have seen this. Many of our attendees on the call today, when a loved one passes away, all of a sudden there's all these people coming forward that feel they've got a claim against the estate. And the old saying goes, when you die, what's going to happen? And we know that you need to have a plan in place. There needs to be structure. You need to understand the process, because really failing to plan is planning to fail.
Jeez. So let's talk about, the reality of the other person. Obviously, I've heard in these sessions when you talk about wills and you say, why don't you have a will? And other people say, well, I won't be there, so that's not my problem, and that's how they look at it. But for the people who actually want to be here and who do take care of their family members, that is also a reality. You won't be here. But the list goes on of things that basically still need to be paid. Fees need to be paid. Yeah. Groceries still need to be bought for the children, paying up your bond. Your assets may need to be sold to acquire money to do certain things, the funeral itself. So there's a list that goes on and on and on and on and on, right? So now when people look at this, they think, so now do I need to put all of these things in here? One of the questions that was asked, and I wanted you to jump in on here, Liana, the reality is there's much to be done. Causes a lot of financial stress and, panic. But people were saying the confusing thing is there are free wills, and then there are wills that come with a cost. There are wills that are complex, or can I do it myself? So I wanted to just clear up, because, I've heard you can draft it on your own, because you can buy stationery at like CNA and stuff like that, or for the template. Is that enough, though? Is it valid?
I think it's such an important question, and just to link it in with what you've said, there's still a lot that needs to happen when someone passes away. Life continues for the people that stay behind. And I think this is where financial coaching is such a vital part of anybody's journey, because we have to think about these things. We don't want to think about it. But if I take my situation, I'm married, I've got 2 kids, we're jointly responsible for our living expenses. I do need to have the discussion and ask my husband, if anything should happen to you, will we be okay? How am I going to manage to pay the bond, to pay for their education, the school fees, because we've been doing it jointly. And that's where you need to look at, what type of cover is in place, what type of company benefits is in place, where is your will, is it up to date? So it's very important to have those conversations, and very often it's difficult to have money conversations. But to bring it back to your question in terms of can I draft a will? What is a legal document? How do I do this? And I've noticed someone saying in the meeting chat, I've got a document, but it's not necessarily legal. So we often see in the movies, someone recording and they say, if you're watching this, it means I'm no longer around. These are my final wishes. That's not valid. Maria, I can't come to your office and say to you, Maria, now remember, if anything should happen to me, these are my wishes. It needs to be documented. Yes, you can buy the stationery. We can even assist our attendees with a very basic will template, but there are certain criteria that you need to think about, and we're going to touch on the detail there. But even if you do start with a basic will, there are certain things that you must document in that will. So you have to think about, are you married? Are you in a relationship? Do you have children? Do you need to appoint a guardian if both biological parents should pass away? What type of assets do you have? Who do you want the executor to be? And of course, very important, it needs to be signed, it needs to be dated, and it needs to be signed by witnesses, and it needs to be kept in a safe, secure place. And you do need to inform someone close to you that you have drafted a will and where they can find it. If there's minor children, you also want to mention the testamentary trust, that needs to be formed. And I always say, ask yourself the following questions. Am I in a relationship? Am I married? How am I married? Do I have minor children? Do we have assets together? Do I have financial dependence? And then, of course, if you answer yes to those, then I would definitely recommend that you go the route of a professionally drafted will, whether it is through an attorney, through a bank, through a fiduciary specialist. If you answer no to any of these questions, like my 19-year-old, she could still draft a will, but it will be very, very basic, and it's just to simplify the process. So if your assets are below 250,000, you could maybe get away with a very basic template, or you can even buy the template from CNA. You can download it from the internet. please just make sure that when you do download the template, that it is based on South African law and it's not linked to the UK or the USA. So let's ask our attendees this afternoon, Maria. I'll be interested to see whether they have an up-to-date will.
Very, very interesting. Some people already said in the chat function way earlier, I've got one. No, I don't. I didn't think it was necessary. And I like that they said that in the past tense. I didn't think it was necessary. So it means you ladies are really, really lighting a fire underneath all of us, making us think about a couple of things here or there. So I do want us to actually just respond in that sense. Yes, and it is signed. No, unsure. Yes, but it's not signed. Somebody in the chat function said my mother-in-law has a copy of her will here, but it does have a stamp and it's not signed. Is this legit? The bank told her that they don't keep it with them. So is it legit, Yolanda?
It's difficult to say, Maria. I would like to see the will, because remember, a will over the amount of 250,000 Rand, as Leona mentioned, there's certain rules and regulations. So we call it the Wills Act. So it's difficult to say that it's valid or it's not, but it does not necessarily have to be stamped or certified to be valid. It needs to be signed by all parties. It needs to be witnessed. It needs to be domiciled. So there are certain rules and regulations with regards to the signing of the will. And it is also very important that none of the beneficiaries mentioned in the will are actually signed. They signed as witnesses. So I'm more than happy to look at the will and advise further, but it doesn't mean that it's not valid because it's not certified. I hope that helps.
Okay, there we go. I think you ladies have touched on, the drafted will, but it's not signed and all of that, if it's valid or not. You've touched on that really. And I wanted to just ask you guys, what somebody asked this indirectly, who can contest a will? So I wanted to ask in this regard, what makes a will valid? And then we can go into who can contest it and under what conditions. But what makes a will valid? Liana, do you want to talk us through these points?
Yeah, definitely. So earlier on, I mentioned about the video recording or popping my head into your office. So the will definitely needs to be in writing. It needs to be formal. You also can't really jot it down on a serviette or at the back of a slip or whatever the point is. It's got to be done properly. It must be signed by the testator. That's, of course, the testator or testatrix, the person that is actually the owner, if I can put it that way. There must be two witnesses, and they don't have to know what the content of the will is, but they are witnessing that they saw me sign that will. How often do we do this where I might need to sign a legal document? I come to the office and I'll quickly say to my colleague, oh, you must know this is my signature. Won't you please just quickly witness that I did sign this document? And I'm going to ask Yolanda to share her story with us about signing for a witness when you're not in the same room. And then, of course, it's got to be signed, initialed on each page. And I think really very important to note again that all parties who are signing, whether it's the testator, testatrix, witnesses, need to be present at the same time when this document is shared. Yolanda, do you want to share your example with our attendees this afternoon?
Yes, I will. And so for those of you who don't know me, I'm a very honest person. And unfortunately, Maria and Leona makes me share this very embarrassing story with everybody all the time. But I'll share it with you again. So before Capital Legacy, I actually worked for one of the big 5 banks. And here I am, this good friend and such an amazing colleague. And my colleague came to me, she said, Yola, please just sign as a witness. I didn't have anybody there. I'm like, okay, cool. And I signed it. And unfortunately, that client passed away. The wife knew that there was no second witness. So when the husband died, she contested the will because she wasn't happy. There was some nomination to kids that was obviously not theirs together. So she wasn't happy with what was in it. So when he passed away, she contested it because she knew that there was not 2 independent witnesses, which made that will invalid. That also meant that I had to go to court. And I had to also be very honest there and raise my hand and say, I signed and I wasn't there. So it's got repercussions. So never, ever, ever sign as a witness. No legal document if you are not there. And they pick it up. They're clever. They're very clever. So sometimes the testator or the testatrix will sign in a blue or black pen, and then the witnesses will sign in another color. They pick it up. So be very careful. Make sure that you're there. Make sure that you sign, in the same color pen, and just do it right to make sure that nobody contests it. Because I saw the question, who can contest it? Really, anybody. Anybody who's got questions, especially if they knew they were not witnesses. I've had families contesting because they feel that the mom or the dad, they weren't in the right frame of mind. They couldn't remember anymore. They had Alzheimer's. So if you have Alzheimer's, for instance, you cannot update or change your will or do a will. So it depends on the reason for the question of contesting. But at the end of the day, remember, when you pass away and they've started with the finalizing of the will, everything is actually in the government gazette. The whole liquidation and distribution account is in the government gazette, I think, for 21 days. So anybody can go and contest what is in that liquidation and distribution account at the end of the day.
So now that we're getting into the who's who can contest and who can, I wanted you to please just explain to us what an executor is, and if I can just appoint any executor. I saw in one of the slides Diana was taking us through with the Interstate Succession Act, it says the court will appoint an executor. So I wanted you to please take us through the role of the executor and who can I appoint as an executor.
Thank you. Liana, am I going to take this one?
Yeah, absolutely. Go for it.
Thank you. So it's really important to remember that you can nominate anybody as an executor, but this executor needs to be approved by the Master of the High Court. So I'm just going to use an example. I do not have the qualification. I have never worked a day in my life. My husband really looked after me really nicely with me and the kids. So I don't have any background. I don't have any qualification. If I am the executor on my husband's will, the master might decline this nomination. So if the executor can be one of 5 people or institutions, so it can either be a bank, a lawyer, a CA, a fiduciary specialist company, or somebody who's actually winded up for about 5 years or longer. And really, to our audience on the call, to appoint your spouse as the executor is really, they are mourning your death, and they don't necessarily have the relationship with SARS or the relationship with the Master of the High Court or the relationship with the bank. So your personalized, your individual person, it really takes time to wind up the estate. And if you don't have these relationships, it can take really long. So please, I am asking nicely, do not appoint your family member, or you can appoint them as a co-executor if you feel uncomfortable, because then, they still work with the executor, but the executor does the job. So just going back, what is the executor? The executor is the person who gets into your shoes and finalizes everything where your ID number was nominated or mentioned. So they have to close your account. They have to settle your bond. They have to transfer the property. All of those things needs to be done by the executor. And that's also why it's important, before you nominate an executor, you know what the capacity of that executor and the staff is really, so that the estate doesn't take 2, 3, 4 years, so that the estate's consultants can go out and see the family and have a relationship with the family, because there's nothing worse than phoning someone and you're just in the queue number 550.55 in the queue. By the time somebody answers the phone, they don't really know who you are. I've seen clients who reached out to me for help where maybe the lawyer that they dealt with is a divorce lawyer, and this divorce lawyer is in court all day. So nothing is happening with that. And unfortunately, it's a really big process to actually go and report that and get another executor. I hope that answers your question. Liana, would you like to add?
Yeah, I think vitally important just to make the right choices. And of course, this is where you get the guidance of financial coaching to help you make those decisions. I know we're going to get to the different will drafting options and what would be the pros and the cons and the risk around it. So I do want to encourage everybody posting your questions in the meeting chat. I promise we are covering the most important content when drafting or considering drafting your will. But my eye caught something here, which I just quickly want to ask you, Yolanda. And the question is, can the executor also inherit?
Yeah, no, let's not do that. So there's conflict of interest there. So the executor, same principle applies, that if you're a beneficiary, you cannot be a witness. It can be a huge problem if you're the only beneficiary and also the executor, because there's conflict of interest. We have had wills where there's one child, that child is the beneficiary, the estate is under the amount of 250,000, and they are also the executor. Then the master doesn't have a problem. But as soon as the master picks up, there's all of these kids, and now all of a sudden you're the executor and you don't have the qualification, the master can decline the nomination because of conflict of interest. So in order to make sure that there's no delay, rather you cannot be a beneficiary and the executor. It depends on the situation. Once again, there's different backgrounds and different ways of doing things and reasons why you can do it, but I would suggest not to do it at all.
Thank you, ladies. Liana, I wanted to ask you if you can get into the do's and don'ts. So just the simplest tips you can give people with regards to, don't do this, don't do that. Like Yola just said now, let's not do the executor being a beneficiary as well. What other things top of mind can you think of that we should not do?
I think out of the points that we're seeing on the screen, I would like to highlight maybe the ones that you cannot disinherit needy children. If they are minor, financially dependent on you, you cannot disinherit them. If you're in that life stage where you're a parent of a teenager or a young adult child, very often we feel like we want to disinherit them, but we can't if they are financially dependent on you. And also, it's very important to keep it basic. Don't overcomplicate it. I know that in the past, Yolanda has shared many examples where we say don't try and rule from the grave by putting in ridiculous conditions in the will that can't be executed and just delays the process. So really try and keep it as basic as possible. And then, of course, you can also include a letter of wishes. And those wishes could be something like whether you want to be buried or cremated. But once again, you also need to mention this to someone because the will, of course, is read a good couple of weeks after the person has passed. Yolanda, is there anything that you want to add to that?
Yes, thank you, Leona. So I'm just going to share two examples. So the first one, I had a client, she was a private banking retired lady, and she wanted in her will, stated that she would like to be cremated. Her ashes must be thrown in the botanical gardens, under a tree. We must put up a chair. We must put her name on it. And unfortunately, she didn't tell her family members about that. And 2 weeks later, when the will was read, she was buried, unfortunately. So it is really important. You can put these wishes in your will, but it's important that you share that with somebody that you care or that you love, at least one person. Where is your will and what your wishes are at the end of the day? And then another just quick one. I see that we're running out a little bit of time. The other one, I had a client who wanted to put in my daughter are not allowed to inherit until she's, I think, 25 years old, but she must also have a degree. Unfortunately, that daughter was in a car accident and not mentally capable of doing that. Okay, it is not the responsibility of the executor to make sure that that happens. I had the one last week, literally, that the husband said, my wife is not allowed to inherit if she has a boyfriend. Unfortunately, once again, I cannot, and the executor cannot make sure that that happens. So whatever you put in the will, it must be executable at the end of the day.
So before you ladies continue, now listen, I know I'm pushing it here. For most people who did join at 1, they are thinking, what are you going to say? For those of you who can afford to stay a little bit after 3, which I have a sneaky suspicion we're going to go to because of so many questions being asked, please do stay. Let's see if we can squeeze a couple of minutes extra into it. Those of you that did join at 1 are probably throwing something at your screen right now, aiming at me. But I really, really feel like it's a beneficial conversation. If you can stay, please do. If you can't, we fully understand. But I wanted to both this scenario and another very interesting one that I wanted to read so that we could just get the benefit of hearing your expertise around this, Yola. The question is, if there is a will that's drafted by a parent, and the state excludes the children over the age of 18 from receiving the parents' money, and some of them get a certain percentage which is not equal that of the children that are under 18. Do you know the reason why this may happen?
So under the age of 18, they're not allowed to receive any inheritance in any case.
Okay.
So the only way to do this is, once again, just to draft the will and make sure that you nominate the correct people. If there are guardians, make sure that you nominate the co-trustees to actually make sure that these children are looked after. I hope that answers your question.
It does. So there was a point about not disinheriting needy children that Liana mentioned there. So if you've got a 19-year-old and you don't put them in your will, is that disinheriting a child, or is it because they're older than a minor, you can exclude them?
So yes, if they're older than a minor, older than the age of 18, and they are not financially, dependent on you, they're out of school, they're doing their thing, they're working, you're not feeding them anymore, yes, you do not have to nominate them. That does not mean that you're disinheriting. Say, for instance, that 19-year-old is mentally incapable, for instance, still staying with you, you are feeding them, you are still, bathing them, then that you cannot disinherit a child like that.
Okay, makes sense. Like it. I like it. Okay, so this I want to speak to. I didn't want to skip. Definitely, very important one. So Jane is a single mom who is in an abusive relationship. She has a daughter that is 9 years old, and when she passes away, will the father of her daughter actually, get the legal guardianship of this child? Remember, this is an abusive relationship in that sense. So that's why I'm asking. What would you say to somebody like Jane?
This is very sad, Maria, but this is the reality. And once again, this is why we are having these sessions. Unfortunately, if Jane did not go to court, and, the court said this parent is unfit, or the father is unfit for the following reasons, unfortunately, he will still be the child's guardian. The only way to get around this is for Jane not to wait wait for her to pass away before she does anything about this. It is important that you start the process now, and it can be a very long process, and it also costs a lot of money. But rather start with the process and, add any police records, any photos, any people that knows what's going on, contact details and email addresses. Make sure that you add everything like that to a copy of the will, and make sure that guardian that you have appointed, which is now not the father, the unfit father, as an example, so that guardian is aware of it. If you do not do that, and the guardian that you appointed is actually aware of what's going on, then it is then the responsibility of that guardian to go to court and also pay for it. Remember, it's not going to come from the estate. The problem that we're finding there, if there's nothing mentioned, no police records, no case numbers, no photos, then it can happen so that the child can go into a foster home until this whole process has been sorted out. So my message to our audience on the call, if you are in a situation like that, make sure you have all the facts and start with the process now. Do not wait, before it's too late.
Thank you for that. I think that's very informative. And I'm going to jump over to you. We're going to talk money now. But first, before we talk money, I want to talk, firstly, how long this takes to wind down the estate. Yolanda, you'll speak to that. But Liana, we've heard people saying it costs more money to be to pass away than it is to be alive. So if you can just give us an idea of how long it takes to wind up an estate, and then maybe start talking towards the costs and the standard of the cost, and maybe you and Yolanda can just talk around how do we prep for the costs.
Yeah, absolutely. I think just to jump in, it can take, if there's a will in place and it's not very complex, Yolanda, you can correct me here if I'm wrong, but I think it's anything between 9 to 12 months. If it is a lot more complex, of course, it can take slightly longer. And if there's no will in place, it can take a number of years.
I agree, Liana. So that's why I said it's so important that you choose your executor wisely. So it depends on the capacity of the executor. I've seen between 2 and 3 years, depends on the capacity again. But then also just remember, sometimes we choose our executor wisely, but then we're in a situation where the master of the High Court, the offices are closed, or it's burned down, or there's COVID, or the your SARS affairs are not in order. So remember, any estate deals with a lot of third parties. So normally, and it can so happen that it's not always the executor's fault that the estate's taking long. We are waiting for the bank to get back to us, or for SARS to get back to us. So there's a lot of things involved here, but a good time, because remember, we also have to do advertising. We have to, we have correspondence. There's certain rules and regulations, what has to be done, and the master signs it off. So in order for that to go the full course very quickly, you can do it between 6 and 12 months. I would say. But other than that, very, very long if you don't have a will, because then it goes in state and we need to find family members and blood relatives.
Absolutely. And then not only, you are, of course, mourning the loss of a loved one, but now you also might find yourself in a financial predicament because you've been relying on that person's income. Now it's no longer there. You're relying on benefits to pay out, etc. But this is, of course, the segment of the session where we need to talk money, and it is important to understand the cost associated when dying, why the fees. So we spoke about the executor. Remember, it could be a bank, a fiduciary specialist, or an attorney. Some people opt to appoint a family member to try and get away from the executor fees, but then, of course, like we've mentioned so many times, if this person doesn't have the know-how or the capacity, you're actually not doing yourself any favors by appointing that family member. So the executor fees are calculated based on the total value of the estate, and that is around 4.02%. Then there's also trustee fees. If you've got minor children, remember, on your passing, when the will is executed, the executor will then set up a testamentary trust. So there's a setup fee, which is calculated at 1.14% of the value of the estate. But the one that really catches up with many people is the ongoing fee, which is calculated at a 1.60%. And I'm going to give you a real example. If you have property or assets that needs to be transferred into the remaining partner or spouse's names, that would then also cost money. If I take my situation, we've got a joint bond. If I should pass away, I've got credit life in place, which will settle the outstanding bond so that my husband and kids can still remain in the property. But my portion needs to be transferred into his name solely, and there's an attorney involved who would then charge a conveyancing fee. Some of the other fees that people might not be familiar with is, of course, the master's fee. There's an advertisement fee because this now needs to be published, and anybody who's got a claim against the estate needs to come forward. There's the normal post and petties. There's bond cancellation if the bond needs to be cancelled. If the property needs to be sold and you make use of an estate agent, there would be commission payable, and very important, tax. The person who passes away, the taxes need to be up to date, so a tax specialist will be required. And unfortunately, debt does not pass away with the person. So all of the debt would need to be settled as well. And this is where you need to check and make sure that your facilities have got a credit life policy linked to it, or maybe you've got a separate policy which would then cover all of the debt so that your beneficiaries can actually inherit. Rates and taxes need to be up to date. So there really is quite a bit that you need to consider. If you are feeling overwhelmed around all of these fees, we're going to give you an option to reach out and speak to our financial coaching team who can look at your unique situation and give you guidance. But I quickly want to share a real example with you. This is Mary. She's a single mom. She's got 2 minor kids, age 6 and 8. She's got a property worth 1.2 million, and she's got life cover where it would be to the benefit of the kids to the value of 3.5 million. Sadly, Mary passes away. So in her will, she stipulated that a testamentary trust must be formed for her kids. The life cover will pay into the testamentary trust because the kids can't inherit, and she doesn't want the money to go to the guardian or the guardian's fund. And then, of course, from there, property will be sold, forms part of the estate, or she could say it needs to be settled and transferred into the names of the kids. What would her basic estate fees look like? So the executive fee, based on the value of her estate, would come to around 188,000. To transfer the property would be around 13,000. And then to set up the testamentary trust would be just under 40,000. But look at the ongoing fee. Remember, the kids are 6 and 8, and she stipulated in her will that they can only inherit when they get to the age of 21 or 23. So this estate, the testamentary trust, needs to run for a good number of years. So the total costs associated with Mary when she passes comes to just over R1 million. So this is usually where people say, well, what's the point? You know, why do I draft a will if it's going to cost so much money? And I think we now understand the benefits of drafting a will and why it is important. There are certain solutions that you can look at. And I've so often heard this, you know, that the person that drafts the will, when we talk about the fees, they say, oh, it's not going to be my worry. The people, the beneficiaries or my family could cover the cost. But the reality is many South Africans are struggling at the moment financially, and you might be placing the family member in even a worse financial situation if they need to cover the costs. Remember that you could potentially negotiate the executive fees up front, but there might not be a huge discount, or you can make provision through a form of an insurance type solution. So whether that is taking an existing life cover, increasing the value slightly, and stipulating that a portion of that needs to go towards covering the legal fees, you could take out a separate policy for it, or you could simply just say, you know, not going to be my problem. So a couple of things that you need to consider, but please do reach out and get professional guidance. I think we also need to quickly talk about the different will drafting options.
For sure. I think the will drafting options are quite important because then we've talked about, well, you know, what are my stationary options? Can I go to CNA? Can I do it? Can you do it? You know, so I do want us to talk about the drafting, and people are, you know, knowledgeable about it in terms of the bank can do it, my lawyer friend can do it. But can you talk us through some of the options to consider?
Yeah, absolutely. So remember, we spoke about the basic will template, which we are happy to share. You can even purchase this or download it as long as it's according to South African law. And maybe just think about this. If your estate is less than 250,000, if you don't have minor children, a partner, a spouse, assets, that would be sufficient for now, but you need to update that as you go along. I would definitely say if you are going that route, complete it, have it signed. Welcome for you to send it through to our team so that we can check and make sure that it is completed correctly. If you want something that's professionally drafted, we can definitely recommend that you speak to an attorney. There's a little less risk because it is at least a professional. The cost associated with this, it will depend on the complexity of the estate, but usually it ranges anything from 350 to 1,000 Rand to draft this will. It's not to say that you are then appointing the attorney as the executor. You can, of course, approach your bank during National Wills Week or Wills Month. many of the banks will draft the will for you at no cost if you appoint them as the executor. Lower risk, it's done professionally, but you also need to think about the ongoing fees. Are they willing to negotiate the executor fee? What happens if I need to update my will? Is there an amendment fee? And of course, if it's kept in safe custody, is it going to cost me money? Or you could go the route of having it done through a fiduciary specialist, an independent company, someone like Capital Legacy, where they draft it for you at no cost. You've got the benefit of consulting with a will specialist to have a look at what is the total value of your estate, how will your estate cover these fees, and they will then also match one or two solutions that could potentially help you.
Sorry, I had muted myself. Thank you so much, ladies, for that. So I saw this. Somebody said, can somebody use my copy against me earlier on? Somebody said, can somebody use my copy against me? Can they take a will? And, later on, just surprise, I also have the same copy. Where do I keep it? We've had a lot of people saying one of the wills is here. It's not signed. It's not validated. Where would you say we must keep it as safekeeping, and how many copies?
Sorry, thank you, Nulene. Sorry about that. I'm talking my voice. Thank you.
Oh, I thought it was just me.
Thank you, guys. Sorry. Anyways, 3 copies. Why? Because when you do pass away, the executor needs the original will. So you keep one. I would suggest you give it to somebody that you love and care, and then maybe make sure that your broker also has a copy. Okay, so sign 3 and make sure that somebody knows about it, because we've had situations where the client never cancels his will with, for instance, the bank, and the family don't know where the new will is at. Remember, there's no one universal system where I can punch in your ID number and see where your latest will is. So I also suggest, if it is possible, you can always make sure that your HR also knows where your latest will is at. I hope that helps.
Awesome. Yolanda, can you still hear me?
I can. My mic was muted.
Okay, awesome. I don't know what happened. Thank you so much. I hope we didn't lose Liana. Liana, please just join us as soon as you can. Not too sure what happened with that there. But, the question is that I've updated my beneficiary nomination forms and I've not yet drafted my will as yet. My family, will my family be protected? So this question has come up a number of times in the chat. Hello, welcome back, Liana. Sorry, I don't know what happened there. Welcome back. Thank you for joining us again. So this has come up many times in the chat, this question of saying, my beneficiary nomination forms are updated, but I don't have my will drafted yet. Are those people safe if I've appointed them as beneficiaries on my policies directly?
So no, it's very different. It's 2 very different documents. So it's vitally important. Yes, you could update your beneficiary forms, and you should do an annual audit, but you also need to have a will that runs with the beneficiary nomination forms. Remember, there is so many different variables that we need to look at. So please update your beneficiary nomination forms if you have them, but you also need to, of course, make sure that there is a will in place. Vitally important. Yolanda, I think the next question or the next scenario really is something that I would like to ask you. So this is Dave. He recently lost his wife. He's struggling to deal with his grief as well as deal with the admin related to winding up of the estate. His late wife handled all of the finances. She had a will in place but had nominated him as the executor. What guidance can we give to Dave? How can we support him?
Liana, and unfortunately, this is what we've seen quite a lot, and that's why I said earlier, if you can, do not appoint your spouse as the executor. I would say Dave, go and get professional help because you are mourning. So if you now go to somebody, maybe a child or somebody who's got a bit of background but never winded up estates, then the process is even going to take longer. So my advice to Dave would be rather go to a professional, go to a bank, go to a lawyer, go to a fiduciary company, do a little bit of homework, and rather get the professionals to do it once and then it's done, and he can still go back and mourn the death of his wife.
Absolutely. And I think really, what would we do in a situation where we now listen to all of this? You might say, okay, fantastic. What are the next steps? What do I need to do? And I want to say to everybody on the call today, you've got an opportunity through the Kaelo Ask Nelson program to reach out for free and confidential financial coaching. All you need to do is simply scan the QR code, which is displayed on the screen. At the end of the session, I'll be posting this link in the meeting chat where you can simply click on it, come through to us. We'll help you. We'll guide you in terms of your unique situation, take you through the different will drafting options, the pros and cons, and connect you with the right partner to help you. I know we need to start.
I've put the link there. I've put the link there.
Yeah,
so you don't have to worry.
Thank you.
Yeah.
Thank you so much.
We probably do have to start wrapping up, but the joint will question, just to ask you ladies really, really quickly. Somebody asked there, if I have a joint will with my partner and we are married A and C, and later on my partner then goes and drafts their own will outside of my knowledge, is that will still valid? So firstly, if you can talk to whether or not it's a good idea to do a joint will, and if somebody can go and do a second will outside of the joint will that you guys have.
Yes, Maria.
I'm going to ask you to answer that one because I know that's your area of speciality.
Unfortunately, Maria, I've been in many appointments where people will do wills and then later change it. This is unfortunately life. But I'm going to go one step back. What is a joint will? A joint will is two wills, my instructions and your instructions, in one document. Okay. The problem with that is I've got an ID number and you've got an ID number. Now you and I are married. One of us passed away and the other one is still in hospital. So remember what I said earlier, when one passes away, in order to get the letter of executorship, we need to send the original will to the Master of the High Court. Now, the spouse's instructions of the will is in that document as well. And there goes the will now to the Master of the High Court to get the letter of executorship, right? Now, unfortunately, the spouse is in hospital. 3-4 months later, she passes on as well. The executor cannot start with her estate because we can't get a letter of executorship because her instructions is in that joint will. Okay, so it's very important that every ID number should have their own will. If your spouse, it doesn't matter how you are married, anybody can do a will and change it without your knowledge. Okay, doesn't matter how you are married. So say, for instance, my spouse goes and changes his will afterwards. Unfortunately, there's nothing I can do about it. It's the right of testation. Okay, anybody can change it. Just remember, it depends on how you are married. So say, for instance, you are married in community or in community of property, right? And so that means you own 50%. If your spouse now goes and says, I'm married to you, but I don't like you, I'm not going to give you 50%. Unfortunately for him, but fortunately for the other spouse, your marital regime comes first. Okay. So even if you don't tell us that you are married and your will says everything goes to my scalumpi, and we pick up on the ID number that you're actually married in community of property, your marital regime comes first.
Okay, that makes sense. So thank you very, very much for that. Liana, I think then maybe if you can just walk us through some of the necessary protection elements that we need in order for us to prepare, unfortunately, for all the awful things that may happen. Death will happen. It's not a if or a maybe, it's a when. But there's other critical protection elements that we need in place. Can you talk us through those?
Definitely, Maria. And, if you are working for a company where you are receiving company benefits, you might already have some of this cover in place. We refer to it as your risk cover, which is on your life. So should you pass away, you might be getting a benefit, or your beneficiaries might be getting a benefit. So please check in. What are your company benefits? What are you covered for? But it's also a good idea to have this discussion with your independent financial advisor, because they need to look at your specific needs. Is the cover that you have in place through the company benefit enough, or do you need to take out separate life cover, disability, or critical illness? Always ask yourself the question, why do I need life cover? And if the response is, well, because when I pass away, there's debt, and I know that the estate can't be wrapped up if there's debt, I would like the life cover to settle the debt. Or I've got minor children or young adult children, or I've got an elderly parent that I'm taking care of, and I want to make sure that they are still financially taken care of. Or I really want to use the funds for my funeral, to supplement my funeral policy, or to even cover some of those legal fees that we spoke about, the executor, the trust fees, the transfer fees. So very important to have that conversation, but also do a bit of an audit, check in on your insurance policies. What type of insurance do you need or do you have? And look at things like your funeral cover, your bond cover, your credit life policies on your credit facilities. Think about, if you are no longer in a position to work, something happens to you, how will you supplement that income? Please do an annual review on your motor and household insurance, things like your handbag, your cell phone cover, little things that we very often tend to forget about, but vitally important to do that check-in. I'm going to start wrapping up, and then we can just quickly have a look and see, is there maybe any questions that our content did not cover? But I want to leave us with the final thoughts. Remember that only an original and signed will is valid, must be signed. Witnesses signed that they saw the person signing this document, must be in the same room when signing it. And then, of course, very important, remember to create or stipulate that a testamentary trust needs to be formed for your minor children. Remember that your guardian nominations are only a wish. You need to have the conversation and make sure that they are comfortable with that. And then your will only deals with life cover that pays into the estate. And this will be a situation where maybe you've got a life cover policy and the beneficiary is the estate because you wanted to go to your minor children. That will then form part of the testamentary trust, and to make sure that the funds are not going to the guardian's fund or the guardian. Please remember that no one can inherit unless all outstanding taxes and debt has been paid and settled. Remember that wish document. If you are an organ donor, or maybe you want to be buried or cremated, put this in your wish document, but also tell someone close to you that this is what you want, because remember, your will is read a good couple of weeks after you have passed. And then remember, you can't cater for every eventuality. Remember Yolanda's examples of the dad that said the daughter can only inherit if she goes and studies in a certain direction. And unfortunately, she was not capable of doing that. So keep it simple, easy to execute. And I think really just make sure that you do draft that will so that you've got that peace of mind. So I think our final question is, do you need assistance with the drafting of your will? While I activate this particular question, I just want to wrap up by saying life certainly is very uncertain. It's filled with highs and lows, ups and downs, positive, negative life events. But one thing that is certain is that unfortunately we are all going to pass away at some point in time. Rather reach out now, speak to a financial coach, make sure that you've got the right policy in place, follow the right procedure, update your will on a regular basis or whenever there's life-changing events. But remember, you also need to update your beneficiary nomination forms, vitally important. And then finally, of course, you can reach out, speak to a financial coach on the different will drafting options by simply scanning the QR code or by clicking on the link which is displayed in the meeting chat. Maria and Yolanda, that really is our content and the questions for our panel. Thank you so much. You were a gracious host. Yolanda, thank you so much for being on the call with us. If there's any questions that you feel we might need to go back to, Maria, anything that stood out to you that maybe we really did not cover in our content, maybe we can address it, or I would then definitely ask our attendees to please reach out through the various access points and to connect with our coaching team.
Thank you so much to both of you. I was just the hostess. You guys brought a lot of expertise, a lot of knowledge and experience. We appreciate that quite a bit. There is so many questions. I think in one way or the other, we have definitely covered. What I did actually see just at the end was something just to close us off nicely. I hope I can find that. Joanna, I know you were typing something, but the words got meshed up one way or another. So I can't make out, what you were trying to say. But Joanna says that if the main breadwinner passes away, is there any way that you can still be covered while his bank account is frozen? So I think this is what we were talking about, to say life goes on, but unfortunately things like bank accounts get frozen. Winding down the estate will have to basically be observed, and there's no way around it unless there's payment of policies. And that's the last question I was getting to. They wanted you to discuss the difference between policies that will pay out directly to you and policies that will pay into your estate.
Okay, I'm going to take that one, Maria. So remember, everything with your ID number will go into your estate, right? Okay. So for instance, let me put it to you guys, things with no beneficiary nomination will go to your estate, most of them. Okay, but when there is a life policy and your wife, for instance, is the beneficiary on there, that wife will then receive the policy, and it will not go through the estate. Okay, so it depends on what your needs are. Make sure that there's an amount maybe payable to the estate to cover the fees, and then some section or some portion then goes to the spouse to look after the kids while this has been finalized. Leona, I don't know if you would like to maybe just add something to that.
No, I think you're spot on. I'm happy with the response. Thanks, Yolanda.
I think that's us neatly, tidily trying to close it up. Thank you so much again to those that have been waiting since 1 o'clock. We truly appreciate your time. We're very sorry for having wasted some of it. It was not on purpose. Technology got the best of us. And those of you that did join it too, also, we appreciate your time just as equally. Thank you so much for making time and listening to us and sharing your questions. And hopefully you'll be able to reach out to Ask Nelson so that you can get your assistance with your wills drafting, and get some of these questions to be answered in a personal and private and confidential capacity so that you can get all the help that you need. Ladies, thank you once more. Thank you so to much. Kaelo for setting this up. Thank you, Daniela, for setting this up. We appreciate it. Goodbye, everybody.
Goodbye.
Thank you, everybody. Bye-bye.
Bye.